Hi, Claire, how you doing?
Hello, sorry, I just had to grab somewhere. How are you two?
You're back from London.
Yeah, I got back in Nottingham, don't worry.
Well done. We're all good, thanks you.
Yeah, long story. I wanted to get back for this. So
Oh,
uh,
thank you.
anyway, so yeah. How are you, Ian? You all right?
I'm all right, thank you very much. Yes, yes.
Welcome to the madness of what we're about to do. So if I just give you some idea of what we're going to be doing. I've done this quite a few times. But what I wanted to focus on today is the current rules around self-employment in the industry and how
Yeah.
that should work in a salon. So how we normally do it, and Chris knows this very well, is I ask the hairdresser questions, Ian, if I can make sense. So I'll ask, what it means really, and how these guys see it. Um, and obviously then you're touching on Wednesday with the Hair and Barber Council. It links quite nicely into that with regards to what we're doing with the future employment rights reforms, and we'll talk about that as well. But if it's okay with you today, I want to break it down to when somebody walks in the door and when somebody engages. So I'm a salon owner, Chris is a self-employed person, you're an employee, and we break it down in that way. One of the things we'll be doing as well is talking to them about having correct contracts. And with regards to so it's a lot around employment status, and it'll all make sense to you. But obviously, as we go along, so we'll be doing more of these, and we'll be doing in open environments as well. It will make sense with regards to how we underpin the foundations of a salon by you guys giving them correct contracts, correct restrictive covenant contracts, which Chris will know a lot about. And in my thinking about it from a logical point of view, my understanding is that when you rent a chair in a salon, it's a license to occupy and there's no control whatsoever by the engager.
Essentially, yes, someone's running a business by letting space in it. If I own a garage and then let out a corner of it to a self-employed mechanic who has his own clients, similar deal. There's very little security of tenure involved there, but yeah, same thing.
Yeah. So you might we're getting questions. You might hear a bit that you go, well, what does that doesn't make sense to me, but I'll interpret it if that's okay.
Sure,
Okay.
sure. I'll try and speak English if I can, but
Chris is very used to doing this with us, aren't you, Chris? So
Yeah, yeah.
yeah,
I mean, I was going to just come across with as a friendly face, Colette, and say,
yeah.
along the lines of, we've been the champions for your industry for the past 4 years.
We're going live shortly. We already have people on, so just so you know.
Okay. And
well, actually, before we go live,
of course, yeah, just straight down the corridor.
Excuse me, I just better make preparations to make sure I've just drunk a cup of coffee. So, Colette, if you just give me 2 minutes,
Yes,
please.
of course. I'll just set it up ready.
Yeah, okay.
Yeah, so it's straight up the top and turn right, and so going into the kitchen downstairs. Yeah, all right. I was going to say, Colette, that your your employment contracts is arguably just as important as your insurance contract.
Oh, 100%, if not more
And
so.
employees can cause significant business interruption. So I was trying to come at it from the angle of,
Yeah.
we've been there and done it before.
I know. So I'm just waiting for it to happen. Come on, guys. Sorry, Chris. I won't be a second. Try it again. Sorry, Chris. Won't be a minute. How have you been anyway? You got your thingy tomorrow, haven't you? Bless you.
Yeah, I've got the bloody implant going in.
Have you? Oh, my sister deals with them.
Oh, it's been brutal so far, but I've had the major work done.
Oh, you've got the hard bit out of the way then, haven't you?
Yeah.
Bless you.
Forward to that. Been busy. We're opening up some offices in the city centre.
How are you?
We've been sorting that out as well.
Mm.
You'll have to come to our launch party in the new year.
Oh, definitely will.
Good.
Right, let's work this out. What's going on with this now? Mm.
Very good.
It won't be a second, guys. I'm just trying to sort this out. Technical gremlins again. Here we go. Give me a minute. Won't be a second, Chris. I'm just trying to sort this out. We're 5 minutes early anyway.
What I should do in the chat, I could put the link to our to the website where they can funnel through.
Yeah, perfect. Yeah, it's been a really crazy week, you know.
Oh, I've had so many clients call me today about with the power lines down and stuff. So business.
Yeah, there's trees all over Nottingham, Chris. Honestly, I've never seen so many
Miraculous.
bloody trees. Let me share the video.
I've just popped that in the chat. Oh, it's the hosts and panelists. That might not be the. Not everyone might see that. Do you think, Colette? I've just popped it in the webinar.
Yeah, don't worry, because I'll be sending it all to them out afterwards.
Yeah. Okay. It's there.
I'm just trying to get it to share, and it's decided it doesn't want to share to a group at the moment. So I've had so many emails about this today as well, Chris. It's just ridiculous.
I've seen all the comments online. It's been good. So clearly everybody needs it.
Right. Okay. I think we'll just start because I've said if they're not, they've got to basically be on it. It's really important. And then I'll share it to live. Okay, so okay. Oh, okay, we'll do it from here. Right. Okay, so good evening, everybody. My name's Colette Osborne. I'm founder of SOU, as you all know. Then we've got the lovely Chris Guy here from RLK and Ian. I think it's Edgbaston, isn't it? From RLK, yeah. That's right. So we've got the Big Balls team in with us this evening, and we're talking about basically employment status and what's all the confusion about. The reason we're talking about this is because of all the questions we've been having in the group. So let me deal with housekeeping first, okay? Now, this is not being streamed live to Facebook for a reason, okay? Because you've all got to register to be on this, and it's really important. Anybody who wants this, who have asked me in an email for a recording, I will send that to them. Housekeeping, if you've got any questions you wish to ask, please pop them in the chat group, okay? And then we'll answer anything we can. But what we're going to be looking at today, and the reason we brought these amazing guys on who've looked after us for quite a few years now with regards to insurance, litigation, commercial, and everything else, is so that we can discuss where's all this confusion and what do we really need to know. And the reason I say that is because when you actually look at how a salon operates, it's very hard to know what are the rules, you know, how do we run a rent-a-chair salon? What does it mean? What happens if HMRC come and actually do an audit on us? What happens if, you know, I'm not sure where to go? So we've got a specialist in employment law here, and we've got a commercial specialist as well. So we're really lucky this evening. So let's start. Okay, so we're going to start as soon as let's just get straight into the detail and some of the questions we've had. So I'm going to walk for the relationship in a salon because that's what's tested in characteristics in employment law. Is that right, Ian? So when they actually, if you're in an employment tribunal, they'll look at the characteristics of the relationship.
Yes, absolutely right. In fact, there's a standalone right to apply to a tribunal for a declaration of status. So even if you describe the person who works for you as self-employed or as a worker, you can actually go to an employment tribunal as that individual and say to the judge, well, I think I'm an employee. Is that right? What the judge, in simple terms, is going to do is to look at how it actually operates on the ground in real life. So contracts can be helpful, but in reality, it's how you operate that's the key thing.
Right, thanks, Ian. That's really good, because that is exactly the same as HMRC look at this. So they look at it with regards to the ready mix concrete test. Now, so let's go through how it should work. And I want you to do myth or true or false, however you want to do it, Ian. So I'm a salon owner.
Yeah.
So before April the 6th, 2020, I could come in and Chris could say to me, I'm self-employed, Colette. I want to rent a chair in your salon. He could do that, couldn't he?
Before April 2020.
Before we had the change on employment status and who had to determine so basically I have to determine Chris's employment status now.
You do, although I should add a bit of a rider to that. HMRC and the employment tribunals look at this slightly differently. So it's not uncommon in tribunal to find that someone is claiming to be employed and the judges actually accept that they are.
Yeah.
Whereas HMRC are quite content to take tax on a self-employed basis. So so it can get pretty confusing.
It can, obviously.
But ultimately, if you're in an employment tribunal, the judges have always looked at not just the description that you as the employer, for want of a better word, have applied to the relationship. They're going to look at what the substance is, and that's actually been that way for a long time.
The employment status test has for a very long time.
Yes. So you calling them an self-employed pre-2020, that's a bit of a myth from an employment point of view.
Perfect. Thank you, Ian. Here we go. So let's talk about, so I'm coming into the salon and we're going to talk about how the characteristics of a relationship works in the salon. Okay. So I'm going to tell you what this happens in a salon, and then Ian, you can say, employed or self-employed. Okay, let's do it that way then. So I'm in a salon, Ian, I'm self-employed. It's like Mastermind, by the way. You don't get any prizes for this. There's no cuddly toys going to go across the conveyor belt. Just let you know. Okay, but this is so that we can break it down.
Yeah.
I'm self-employed in a salon.
Yeah.
Chris is the salon owner.
Yeah.
Chris books all my appointments. Am I employed or self-employed?
Right. No one point is going to actually determine whether you are.
Yeah, I know that.
Or not. So if you are simply acting as Chris is simply acting as a diary, in that he takes the call and he says, yes, you're free to do an appointment at that particular time, the answer is probably not. However, if Chris is controlling your diary and deciding when you should work, when you should book the clients in for, when you've got to turn up to do the work, the power imbalance is, or the power balance is such that Chris is directing how you work. So that's one factor. So if that was the only factor in play, chances are you could in fact be an employing.
Yeah. So what I'm talking about here, Ian, and you'll understand it this way, is mutuality of obligation. Okay.
Absolutely. If in the employer and employee relationship, if there's an obligation on you to provide work and an obligation on the employee to do the work, or the worker to do the work, that's one of the key tests for employment status. Yeah.
And the reason I'm coming at it like this, Ian, is just to give you some idea. General practices, Chris is a salon owner. Chris books my appointments. The client books through Chris's name, so it's Chris's hair.
Yeah.
I then have to turn up to do that client.
Yeah.
Now, my determination on that is I'm an employee.
Yes.
Yes.
Yeah. I'm going to add another caveat, because lawyers, we love to hedge our bets.
I know you do. You're good. You are. You can tell you're the big boss team.
What the judges, we get a lot of our interpretation of the law from judges on appeal cases. So you go to the employment tribunal, there's a decision. Someone doesn't like it, they go to an appeal. So the employment appeals tribunal is like the High Court. And you keep those to the Court of Appeal to the Supreme Court. But it's only when senior judges at appeal level make decisions that you start getting a precedent. Now, what the judges have said about the various tests that can be applied to determine employment state is that there are multiple. There are lots of factors that can be determinative, and no one carries it more weight than the other.
Of course.
It depends on each depends on its own individual circumstances. But if you ask me, sort of, would this indicate employment status? I'll give you a yes or no answer.
That's what we're looking for, an indication. So no, it's not good. yeah, we know it's not going to categorically prove one or the other.
Sure,
But I
sure.
think this is for people to actually say, well, actually, do I do that in my salon? And if I do 9 out of 10, they're probably employed. If I do 2 out of 10, they might not be. And this is where it gets really tricky. And you're quite right with regards to how a tribunal sees and how HMRC see it. Let's say can be grey. Okay. However, that is about to change with if they remove worker status, as we both know. So it's about to align with the tax policy. So I'm talking like an accountant now. So I'm just going to describe a situation to you. Then that's the way it is. So let's say, for instance, Chris is a salon owner. I'm self-employed. Chris books the clients in. Chris manages all the client data. Chris tells me I've got to be there on Tuesday at 2 for this client, and I've got to turn up to do it, and they'll only have me. So what I mean by that is, in our industry, it's very rare for anybody to be able to substitute. It's just unheard of. And that being one of the main tests, to my understanding. So when we talk about an unfettered right to substitute in that way, so am I right in saying that I can actually say I don't even have to tell Chris, I can just send somebody in to do my work for me?
Yes, that would indicate that you're running a business independently, because in the same way that, let's say I've got a problem at home, the tap's leaking, and so I book a plumber to come and do the job. Now that plumber could say, well, I've got 1 or 3 people available, I'm going to send so-and-so around, and then phones me up 20 minutes later, so I'm sending so-and-so around.
Yeah.
That's a business in its own right. But perhaps I can draw a parallel with sort of the gig economy a little bit, delivery people, see them Uber Eats and sort of that kind of thing. If they've got the right to send somebody else along to do the job, that's an indicator that they're in business on their own account, self-employed. Yeah. But if the reality is you can't do that, it might say so clearly in the contract, you can do this, then, but you're not permitted to do it, or you can't do it for whatever reason, then that's null and void. It doesn't work. The other thing that you might find is sometimes you might have a fettered discretion. So the salon owner has the right to refuse unless a certain person has got certain qualifications, experience, so on and so forth. Again, that's more likely to be not a genuine substitution clause.
Yeah.
Can you send anybody to do your job? You can't, then it's an indicator of employment. Yeah.
Yep, got it. Perfect. Okay, so you can see how it generally works now, and then I'm going to come on to some questions. So one of the key things, and I'm going to go into this, and then I'll come back to a little bit more about relationship if I can. So the reason we called this today was because a lot of people, obviously employers, are under a lot of pressure, okay, because of the budget and everything else. What we are getting is a huge amount of people looking to switch their businesses. Okay, so what they're looking to do is be employed on a Friday and self-employed on a Monday with no change in relationship, still doing the same clients under the same salon name. The only thing that will change is the description of that worker.
Right. Okay.
So with no break in service bar a weekend. Right.
Well, that's a fundamental change in the nature of the relationship, which is going to almost certainly amount to a dismissal. So if they were an employee on the Friday and suddenly find themselves employed on a Monday, then the ex-employee may very quickly lodge a complaint of unfair dismissal.
Yeah.
And have good grounds to do so. You can't unilaterally on your own change an agreement. So as an employer, I can't turn around to my staff and say, I've just fundamentally agreed that you're going to do your work for me, and have a right to complain to an employment tribunal.
Yeah. Okay. So there's and that makes sense because we've already had cases in our industry. I mean, before April 6, 2020, we had a few, but since that kind of came in, we've had a huge amount. Okay. Right. We had some quite famous cases, mostly being about the relationship, mostly being about, what was happening in the relationship, and all pretty much, well, they all have been determined as an employee. We also had a very famous case, I won't mention the group's name, but where they'd actually done exactly that, Ian. So on a Friday, they were employed. I think it was 2 weeks later, they were self-employed. They believed they could just make them redundant, but come back on the same terms, the same relationship. Bear in mind, we know the relationship was that of an employee.
Yeah.
Came back 2 weeks later, relationship didn't change, clients didn't change, booking regimes didn't change, hours of work didn't change. The only thing that changed was the classification of what they were called.
Yeah.
Now that salon obviously caught a massive cold, okay?
Yeah.
And the key thing is here, and I'm just trying to, I think it's really important for people to understand what risks they place themselves in. Because if we've already got cases cited in our sector, so we don't have to rely on Ubers, deliveries, or anything else, we've already got cases cited. And obviously, the other element of it is from a tax compliance point of view. I know the employment law side, which you've just mentioned, but from HMRC's point of view, they see that very much as continuation of service, which then holds another issue there. So if somebody wanted, let's just put it this way.
Yep.
So Chris has told me on Friday, Colette, right, we can't afford this anymore. Next week, you're self-employed. See you on Tuesday morning at 10. Does that make sense to you? Now, would that indicate that I'm still an employee because nothing's changed?
Yeah, it would, very much so. Again, coming back to the reality of the situation, I can perhaps elaborate a little bit. You couldn't be redundant because you're still needed to do the work for which you're employed. So that's out of the window. But people often misuse redundancy as a descriptor. You're only redundant if the business has a reduced need for the number of workers to do the work for which they're employed. Clearly, your example hasn't changed. So you're not redundant. You are unfairly dismissed because as an employer, you need a fair reason, according to law, to dismiss or to terminate a contract. Usually it's misconduct, capability, or redundancy, which we just described there doesn't apply. So the self-employed person could remain technically self-employed in a sense because they still need to earn a living, but could still complain of unfair dismissal.
Yeah, and obviously from the HMRC's point of view, they'd see that very much as continuation because if the relationship's not changed, then obviously it doesn't matter, does it? Yeah, I don't mean it doesn't matter, but the point is if the relationship's not changed and you're still classified as an employee, then they would still classify that as or that.
Sure. I wonder where you're going next is in about fire and rehire.
Well, that's exactly what I'm talking about. So just had
right, okay, that's a little bit different. In this sense, there is fire and rehire. The new government has promised to tighten up the ability to do this. Fire and rehire isn't necessarily completely changing the nature of the employment status, say from employed to self-employed. It's a variation of the terms on which you are employed. And so let's say the salon is struggling, and someone wants to make Chris is the salon, he wants to make changes for the financial viability of the business. What we have now from July of this year is a code of practice that applies to this, which goes into a lot of detail on when fire and rehire may be
applicable.
But it's still essentially it could be a fair reason for this. So I'll try and put this in plain English, or you can translate for me, Colette.
Yeah.
So the way it works is this: what the new code of practice says is before you fire somebody, what you should do is consult with them, warn them that you need to make changes, consult with them genuinely about what you want to do and why, have a good business case for doing that, invite opinion. If you've got a union, if they're unionised, you consult with the union, probably, but maybe the individual. You go through a process, a clear process. If at the end of it, you haven't managed to reach a resolution, that you've acted in a fair and reasonable manner, and you can show that there's a genuine business case for this to happen. Not that you necessarily want to make more money, but say the business needs to change, otherwise it's under threat, for example, then you could possibly terminate employment and you could offer new terms of employment, say at a reduced rate or different shift patterns or whatever that may be. You'd still have dismissed the employee and then re-engaged them, but you may have had a fair reason for termination. That's the critical thing.
It's about, yeah, the fair and being fair and reasonable and proper consultation and everything else.
Well, I mentioned discipline, sacking someone for misconduct, redundancy, and capability. There's a catch-all provision called some other substantial reason. Okay, and that means that it's to catch those odd situations. But here, this could be one of them. I can give you another example that might help clarify it. Let's say you employ somebody, but in your contract, you haven't put in the necessary protections for your clients and so on. You're worried because one of your previous members of staff has gone off and set up their own salon and is now poaching your clients. You've still got some other employees there, but their contracts don't contain protections for your business. Yeah. So you might say, look, everyone, I'm going to have to change the contracts. I need you to enter into promises that you won't try and take my clients if you leave. If they say, oh, we don't want to do that, you probably be on solid ground saying, in which case I've got no alternative but to terminate your employment. And it would be fair because they won't enter into
a breach on their own right, aren't they?
Contracts that would legitimately protect your business. You're not being unfair. You're trying to close a gap that exists. Yeah. So similar with here. There's got to be a sound business reason for it. Is what I'm saying.
But a sound business reason is I can't afford to pay VAT. Do you know what I mean? Unless it's protected against insolvency.
Yeah, well, can't afford to pay VAT. That's a little bit tricky.
Exactly, that's what I'm getting at. So
yeah.
But let's come back to the term fire and rehire, okay? Yeah. And then we'll do some relationships. There's a couple of questions from Sophie and from Scott, which are pretty much the same. Now, bear in mind, we've had cases on this. We've got a very famous case in our sector where the employees went to the salon owner. This is common, Ian. This is so common, isn't it, Chris, in our sector? The employee goes to the salon owner and says, well, my mate down the road is absolutely smashing it and earning so much more money than me, so I want to go self-employed next week. Okay, so obviously the salon owner's then in a corner and they're going, well, I've got no choice but to do this. So with no consultation, no contractual reviews, nothing. Then what happens is they do what the employees asked for because they don't want to lose them. Okay, 6 months later, 2 years later, and this actually happened in real life. Okay, on 3 judgments. They went back later date and claimed employment status from the salon. Now, at that point, if somebody comes to me as a salon owner, because I'm a practicing salon owner, and says, Colette, I want to go self-employed.
Yeah.
I've got to say, well, what risk am I taking as a business owner? Yeah. Am I determining that you actually are self-employed? Because this is just based on a under duress. This is not based on a business case. It's not based on a decision. It's not based on a consultation. Yeah. In that situation, and let's say, for instance, Chris came to me and said, Colette, I want to be self-employed next week because I want to earn more money. And I go, well, actually, I've got no choice then. You'll have to be self-employed next week. Then Chris comes back in 2 years and says, actually, I'm now having a baby, or I've now decided I want to do something different, or actually I've decided I've broke my arm, so now I want to be an employee. Does Chris have a case against me?
We would look at the facts and say, well, what's the reality of the relationship on the ground?
But the relationship's not changed.
No, so chances are, unfair though it may sound, the judge could say, well, actually, I think you've been employed for employment law purposes throughout the entire period you've claimed self-employment status. Sounds unfair, but that could happen.
But that's what's happened. That's what I want to say. This is what's really difficult for salon owners right now. And this is why I wanted to do this evening, is because the key thing we keep coming back to there is we keep coming back to one key thing, the relationship, the characteristics of the relationship. So one of the key characteristics that was put out, and I've got it all on screen from HMRC, so it might be helpful for me to actually pull that out in a minute. Yep. One of the key characteristics here is who has financial control. Okay, so this is for tax and for employment purposes. So now, who bears the financial risk? Because a genuinely self-employed person, in order to be classed as genuinely self-employed from employment law and tax, has to be able to suffer loss as well as make a profit. Is that true?
Yes, it is.
Right.
It comes down to this simple question: are you in business on your own account? That means it could mean, are you providing your own tools? Are you investing your own capital?
Yeah.
Are you taking the risk, as you say? If you sustain the losses, do you bear those losses? So on and so forth. Multiple things that say, as a solicitor, when my clients come to me, then I'm not their employee. I'm doing work for them as a contractor. That's genuine self-employment status, if you will. It's the outcome that they're paying for, not actually my service, my time as such, if that makes sense.
Yeah, it does. It does.
Yeah.
I've just sorry, I just asked another question by Sophie. Thanks, Sophie, and I will ask this. This is a tricky one because from an employment law point of view, it might be viewed differently from a tax point of view. Okay. So let's do it from an employment law point of view first. And sorry, this sounds confusing. From an employment law point of view, we just talked about fire and rehire, Ian. Okay.
Yep.
Sophie said, can you ask them if they have actually handed in their notice, though? So Chris comes to me on a Friday and says, I'm handing in my notice because I want to be self-employed next week.
Yep.
Now, HMRC won't see it like that.
Right. Okay. Under employment law, if you are an employee and you give notice, that's it. You've just terminated your contract. Okay, you might work your notice, but you're now on a treadmill that's going towards termination of employment at the expiration of your notice. So, just the same way as if one of my members of staff comes to me and says, I want to leave and go and work for another firm of solicitors, that's it. The relationship is going to come to an end.
Exactly. But if this is, all right, and I'll put it another way, if this is people in the nicest possible way, so I'm just going to have to say it like it is. People believe that if people hand in the notice or they make redundant, they can just change them to self-employment. HMRC see that very much as continuation of service, and they see that as potential, well, avoidance, don't they? And that's the difficulty. So I think this is where we have to distinguish between the tax side and the employment law side. So we'll do that in a second. Now, so far we've determined if the characteristics of the relationship are that I'm self-employed, Chris makes all the appointments, Chris makes the appointments at a certain time, I've got an obligation to be there at a certain time to service those clients, I'm an employee, potentially, tick, yeah? We're not saying exclusively or conclusively. What we're saying is that indicates that's it's one in the left-hand column, okay? The next one is Chris manages all the money.
Right.
Okay? So Chris manages all my money. Chris basically sets my pricing. He even tells me what I've got to price my services at. So your cut and blow dries on our website are £40. Okay. I collect all the money and then I take a percentage of your earnings. Who bears the financial risk there? Now, HMRC would see that very much as the salon bearing the financial risk and not the self-employed.
Yeah, I agree. It seems that it's almost like a commission-based income, but you're still an employee, if you see what I mean. It depends on how much you make, how much the salon takes and how much you receive. But nonetheless, you're still employed because every other factor indicates you are subject to Chris's control.
Okay, perfect. Thank you. Because that's what it's all about. It's the magic word, isn't it? And it's control. So coming back to that. So one of the key things in the employment status test, which I've seen in many tribunals, okay, I've got a sheet on this. It's quite shocking because I've took the HMRC guidelines, the employment status test guidelines, and all the judgments where they've failed in each guideline. Okay, and there's a lot of it. Now, one of the key things that has always failed in every single one of them is called integration into the business. I find this really interesting. And the reason I find it interesting is because in a salon, generally what happens is, again, I'm a self-employed, Chris is my boss. Well, sorry, Chris is my salon owner. Sorry, I just called you my boss. We'll go to that one in a second. So Chris basically says, yes, Colette, right, you can share all our resources, you can share all our apprentices. In fact, we'll even share clients. You can do the colour and somebody else will do the cut for you, but you're still self-employed, okay? In every judgment that I've read, and there's not one that has actually passed that test, where they've been classed as integrated into the business, because the other thing is as well, we give people titles. So what we do is we go, Chris goes, Colette, you can now be the salon manager, or Colette, you can train other people in the business, or Colette, you could be our creative director. So he's giving me a status in the business. Now, from HMRC point of view, that's clearly employed.
With employment law likely to be the same, but we shouldn't forget that there is a third category.
At the moment.
Well, but yes, for the moment. We'll come on to that in a minute. Self-employed, employed, but in the middle, sort of, you've got worker status. So you may have heard a few years ago, there was quite a character standing outside the Royal Courts of Justice. It's Pimlico Plumbers.
Yes.
And a chap was complaining. It might have been a little bit of Rod Stewart. I hope no one knows it. I mean,
It does look like Rod Stewart. It does, yeah.
Yeah, and what his workers, they had to use a company vehicle, wear company uniforms, do things in the company way. And what the work, well, as it turns out, he was a worker. He claimed employment status, but actually the Court of, I think it's Court of Appeal, determined that he was actually a worker. So he accrued some of the benefits of employees, such as holiday pay, the application of the working time regulations, right to certain breaks, the application of the whistleblowing provisions and public interest disclosure, that kind of thing. So I didn't get the whole way. So, but you could find yourself in this middle ground. That might change with the new government, but we come on in a minute if you want.
No, we just know what this consultation, which is quite obvious what they're going to do. But anyway, so what I want to get to this, then I'm going to talk about how it can be done from a commercial point of view. Okay. Yeah. So we know so far that, please tell me if this is correct. If we fire and rehire somebody but without the relationship changing, with Chris still having financial control, Chris still booking my appointments, Chris telling me when to be at work, Chris telling me to wear black, Chris giving me all the tools and resources to use. And so nothing changes. Nothing changes in the characteristics apart from the fact that I'm now classed as self-employed. We know that that is still employment status from HMRC's point of view and most likely from an employment law point of view. Yeah, agreed. So we know now it's all about the characteristics of the relationship, not generally just what's written down, but that does not mean that you do not have robust contracts. Okay. Now, let's come on to the next subject. Okay. So we now know any control whatsoever, any, sharing of resources, sharing of this, sharing of that, and the word being controlled. Because one thing that just coming back, HMRC said in a recent judgment, which was quite shocking, the fact that, because they look at ads all the time in judgments, especially from a tax point of view, I know they do from employment law point of view. I put an advert out. Oh no, Chris does, sorry, Chris, you're the salon owner, you've been promoted today. Chris puts an advert out and says, I'm hiring. I'm looking for a stylist with at least 2 years experience. Must have a full collar, must be able to bring your clients, must be able to do X, Y, and Z. Is that, and then at the bottom it says self-employed. Is that self-employed? Because according to HMRC, that's not self-employed.
This is kind of, if you're bringing your own business with you, that seems to me to suggest that you've got an existing business or you're coming from another business with a following.
There you go. You're coming from another business. That's going to bring me on to my next subject with Chris in the room. Sorry, I told you it's like mastermind on speed. Now, Chris, I interview people all the time for jobs. Okay, so let's get into the detail because somebody's asked some key questions here and I think they're really important. We can go through the guidelines on what's control, what the characteristics of the relationship are, and we know quite clearly that a lot of operations in our sector are disguised employees from HMRC's point of view. Not mine, theirs. Employment law point of view, there can be grey areas and that would only be tested in court. That's fair to say, isn't it, Ian? Okay. Now, Chris, I interview people all the time. And the first question I ask somebody, so you come to me for an interview, you want to be employed. The first thing I ask you is, do you have a contract of employment where you currently work? I take it as gospel that you've got a restrictive covenant. I take it as gospel. And the first thing I say to anybody I employ is, they say, do I tell my clients? No, you don't tell your clients. We don't want your business to come with you because we're employing you, okay? So actually, and we know this works in real time, if another salon was to actually go, say, how can I put this? You actually go for a position, you're self-employed, you've decided to change your status to self-employed, you go to another salon, rent a chair, and take all the clients from where you were as an employed salon. Does that make sense? So that comes back to what you were saying, Ian, about protections and restrictive covenants. I've been in this situation and actually took the salon to court and the individuals and won at the Chancery because I have a restrictive covenant. Okay. Now, I always think it's best business practice to make sure that you understand somebody else's obligations because you can actually be pursued for their losses. Is that right, Chris? Under a correct restrictive covenant?
I believe I'm going to take this on as well. It's within my field. I see this quite a lot. Okay. First of all, if you are an employee, or even if you're self-employed, you can have restrictive covenants. Status doesn't really matter. If you're in a contractual relationship with somebody, you say, I won't take the clients with me when I go. First of all, provided they are binding. Now, that's the first question, because those are anti-competitive provisions. So they're only valid as far as they go no further than is reasonably necessary to protect the legitimate interests of the business. Okay, let's assume they're valid.
Yeah.
Okay, so you're at another salon, you're under a restrictive covenant. If you are the new salon, if you are Chris looking to recruit, doesn't matter what capacity, it would be a sensible question to ask, are you under restriction for a period of time from bringing clients with you? And the reason why it's sensible to ask that question is that the courts have power to order you as the new employer, for want of a better description, to hold you liable as well for the person breaking the covenants. Okay, yeah. Because the contract itself might say to the employee or self-employed person, when you go somewhere else, show this to the new employer.
Yeah.
You have an obligation to tell them. If you don't do that, Chris might say, oh, I didn't know a thing about that. Well, maybe, but he's still at risk.
It's just quite common in our sector, and so I thought to raise it because, you know.
On the other hand, if you as the original employer have failed to create restrictive covenants in the contract. Binding ones, yeah. And your employee goes to work for Chris, then it's free reign. That new employee can say, tap up all the old clients and say, I'm moving, going to Chris's salon. Do you want to come?
So let me ask you. Right, perfect. So let's ask another question. I'm just going to ask one more question on employment law, then I'm going to flip to the commercial side, if that's okay. Yeah. So Annalisa, thank you. She said she's got an apprentice in her contract. It states her employment will end when she completes her apprenticeship. Can I take her self-employed after this, or is it still continued employment?
Well, apprenticeship's slightly tricky subject, but essentially what for the apprenticeships we're probably using in England, Wales is slightly different, confusingly. In England, it is now deemed to be a contract of service, so it's employment under Section 232 of the Employment Rights Act. Okay. However, if the contract comes to an end, you then have to offer, it's a fixed term contract, just for a year, yeah? You might offer a new contract of employment, or you might say, well, I want you to be self-employed, but guess where we're going to go with this? You're back to the same tests. And, you know, in reality, the fixed term could come to an end and they could disappear, and that's it. It's all over. For the moment, unless you've got 2 years service, you've got no claim against the employer. But let's say you engage them, they've got to be genuinely self-employed. If you just
exactly, so it comes back to that control and the characteristics of the relationship.
All those multiple factors, absolutely right. So you just can't describe them as self-employed.
Yeah. And what I'm going to do at some point, we did do this previously, I'm going to provide a list to everybody. Well, HMRC are doing this actually. So a list of what you can do and what you can't, what's employed and what's not self-employed. Okay.
Yep.
So let's come back to the commercial side, because one of the things that Scott's asked, and I think it's a very valid question. So we're coming from the point of view that you can't, self-employed can't be done in a salon. Well, it can't if your characteristics are that of an employee. You can't engage somebody as a self-employed person if you treat them as an employee by controlling or anything else. Characteristics again, yeah. Can the conversation? So basically, Chris, Mr. Big Balls team. So I want to run a self-employed salon. I'm not converting anybody from employed. I'm coming at this purely from a new business point of view, totally clean slate. So I've got no issues with continuation of service because I don't employ anybody. I want to do this. So how do I do it?
I'm happy to step in again. Yeah, it is. Okay, I can give you a real world example where it's not the same profession, it's my profession, but it does work. All barristers are self-employed.
Yes.
Okay, so if you go to, there's one of my favourites in Birmingham, St Philip's Chambers, 200 barristers work out of St Philip's. What they do is that they share the administrative costs, the resource costs, the marketing costs, the insurance costs. They pool by paying a fee. They have a committee that manages that kind of thing. They even have clerks who will take calls for new work and may recommend someone. But nonetheless, every barrister is genuinely self-employed. So it is possible to...
They work for multiple clients, don't they?
Ah, that's the difference. Well, actually, is it that dissimilar from a barrister?
It is. It is. Yeah, it is.
If you've got your own clients, and if they're, I'm trying to think of a situation in a large salon environment where there's a brand name saying, you know, St Philip's.
Yeah.
And then you pull the marketing costs, but ultimately each individual chair has got their own clients. There's no crossover necessarily as such. What you're doing is sharing the business costs, but you still dictate when you do the work, if you accept the work. So all the barristers are free to say within reason, no, I don't want to do that work, I'm not available to do that work. I will do it by the following time.
You'll set your own rates and
exactly. Now there may be some consistency. Again, if you look at the barristers Chambers website, it gives the impression of being employed, but it's done carefully and commercially to make sure that you don't stray into the employed category. So it is possible. It requires careful thought, administration, and in reality, this is the test. Is it truly self-employed?
This is the key thing, because Sophie just asked a question. I'm going to come back to what Scott said. So Sophie just said, and she's right. Right. This is why I don't want to confuse people. Yeah. So to clarify, if your employee hands in their notice, a new contract to rent a chair as their own business, so basically own payment system, booking system, separate Instagram, blah blah blah, as everything is above board. Not in the eyes of HMRC, it's not.
Right. You might have a little bit of leeway with employment law. I mean, if you can show that you are now in control as the ex-employee, that it's your business. If you choose not to turn up to work for 2 weeks, for example, that's on you. But if the salon owner can say, hang on, where the heck do you think you're going? You need to be here on Monday. Then it shifts the balance the other way.
Yeah.
So,
but it comes down to the fact that, you know, it still has to be, well, firstly, that would be seen a continuation of service.
Yeah.
So this is why it's I'm not saying it is impossible, because whilst you might have areas that succeed on employment law at the moment, I'll put massive around that, but certainly from a tax point of view, it's going to be seen as continuation.
So tax I can't speak to, it's not my specialist field, unfortunately. So, but employment law, it very much depends. It's possible, but the starting point would be, hang on, this was employment, it still looks like.
But what makes it different? Yeah, if it looks like employed, it smells like employed, it is employed. Yeah.
Yeah, what's changed?
Yeah. Okay. So I think the difficulty is it's very difficult to answer this from a generic point of view. Okay.
Yeah.
Very difficult. And do you know what? I wouldn't want the cost, the stress, or anything else having to be tested in court to prove that I've done it right, not considering where we are at the moment. So let's just do this one. I'm going to say to Richard, we'll have a discussion offline. But with regards to, so let's come back to what we were saying, Chris. I've got a blank canvas. I'm starting a business. I'm not going to put a name above the door because these people are supposed to be independent. So I'm going to look at this like an Into shopping centre.
Yeah.
Okay, that's the way I view it. So everybody can come in if you look at kind of how America do it with the booth renting, that's why they had to go to booth, because the IRS shut it down, didn't they? So if we look at everybody's got their own individual space, I have no control or anything else. Okay. How does that work? Now, my understanding, Chris, please correct me if I'm wrong, at that point, it's not an employment contract or self-employment contract, it's a license to occupy. Although they've got to have a self-employed contract on day one, so that's actually not true.
I mean, in the strict sense, what I'm imagining here is you're on your own in your own self-contained unit in a shopping centre or whatever. Depending whatever legal entity you are, that's a separate business. That could be a sole trader or a limited company. Of course, you can set that up from day one, but it depends, and this is where Ian comes in. It depends on who you're then bringing in to work with you. Are they falling into the employed or self-employed or worker status? And
it's as clear as mud, and this is the problem.
Yeah.
It's as clear as mud because it's on an individual basis. And anybody that's on this call, I would say that if you want to discuss your personal situation, because everybody's different, then we can put you in touch with Chris and Ian, okay? Because there's two things that come out of this for me, is that I don't think it's, from an HMRC employment test point of view, it is clear. It is very clear. From an employment law, obviously, there's the different status and everything, and it gets a little bit grayer. And when the two are probably aligned, then it will be a lot clearer for everybody. But as far as HMRC are concerned, they've put out clear guidelines on this. Okay, so the clear guidelines are, as such, from a tax point of view, as an unfettered right to substitution. This is their employment status test. This has been around for some time. Unfettered right to substitution. Obviously, they look at MU, as you know it, Ian, or mutuality of obligation. They look at integration into the business. Okay, so they look at the right granular detail of characteristics, who holds financial risk. They also now, and they released this in July 22, so I'm not sure if you're aware of this, Ian, but it was the business minister at the time, and I say that because we've changed a lot, and I think it was Jackie Price or whatever it was, Price Doyle, and basically they put out to say that if somebody had one engager, they were employed. So if I actually worked at a salon, this is the HMRC. So if I worked in one salon and I didn't have multiple engagers, so I only had one person, I was working there for 15 years, 5 years, 10 years, and there was a case at 6 months, okay, then I'm employed. Now, they expect people to actually review the employment status, and they said the determination from their point of view was on the business owner stroke engager. So if Chris came to me and said, before April the 6th, 2020, which is why I referred to that, I'm self-employed, I could go, yeah, fair enough. Because that's why a lot of people will say, well, HMRC checked me 10 years ago and I was fine. Well, of course you were. Laws changed, they closed loopholes. April the 6th, 2020, the good work plan came in, blah, blah, blah. And then they said the onus to prove determination of employment status was on the engager or the business owner. Okay. So I had to say, Chris, do you work in only my salon? Are you there all the time? Are you renting there all the time? Are you renting anywhere else? Are you working anywhere else? Or do you just do it at my place? So all of even that conversation's control. So that's how they look at it. And that's what they released in July 22. That's why I was alluding to that area. But one of the key questions, which I think is really important for everybody, and then we're going to come on to contracts and restrictive covenants, if that's okay. So one of the key questions, and I think this is a really important one from Richard, and I will have discussion with Richard offline. I think me and you ought to have a conversation here as well, Chris, if that's okay, and probably Ian. If all of his team come to him, because this happens quite a lot, okay? Because if you remember, I've said earlier, if there's a salon down the road or anywhere that obviously can pay more because they're not VAT registered or whatever else you want to call it, or not paying the employers on costs, then they can afford to pay more. So 20 of his team come to me and say they want to go self-employed. As a salon owner, can I find a solution to make it happen? Or do I lose my team because legally I can't? This is difficult because you lose your business the day you actually do that, because do you see what I mean? This is the quandary people are in right now. Right now, that's the decision they've got to make. So but I don't know, 80% of everyone, something, they are working self-employed, aren't fully self-employed because of the control. Yeah, we know that. So what Richard's saying is 80% of the salons out there who are renting chairs and say they're self-employed aren't by default. The whole industry knows this. That's why we need you guys. Okay, and you're coming quite early on this. So they use same card machines, social media, advertising for them. So under HMRC's eyes, they're employees. I'm not sure I can answer that because, to be really honest, I always try to put myself in other people's shoes. Okay, and you've got the illegal experts here. As a business owner, if I've just built up a business over 10 years, 20 years, 30 years, 5 months, whatever, and as an employed salon, I've got all this client base, do I want to basically devalue my business overnight by giving everything away?
It's suicidal. That for me, from my angle, from the litigation perspective and insurance litigation, the way I see all of this, and I've championed your industry from an insurance perspective, and from a business interruption perspective, I see this as the next business interruption, and it's twofold or threefold. It's the government, it's the HMRC, and it's your employees. It's making sure you're in control now of your destiny, because things are changing and they're changing quickly. And I've been watching it from the wings, and that's why we just want to be here now to assist you in this next huge hurdle to get over.
It is, and I think you're right, Chris, because one of my colleagues said it's going to be the most important 3 months in the salon industry. So coming on to that, Chris, let's think about now. Okay, we have to determine on an individual basis what that risk would be. I think that's clear to say, because just like you said earlier, restrictive covenants. Okay, this is massive in our industry, and one of the key issues with businesses is that somebody decides to leave, takes all the clients, you can't do anything about it. Right. So the first thing is, Chris, how do we protect businesses right now? So I think correct contracts, because my belief is, looking at all the contracts that have gone for tribunal, Ian, I know far more about this, but our particular industry, the generic contract thing,
it's got to be
doesn't work.
Okay, let me give you a bit of insight into restrictive covenants, if I can. It might help the audience. A restrictive covenant is essentially an anti-competitive clause. So you're saying you're going to put a restriction on the trade that your ex-employee can do, or ex-worker, it doesn't matter, also ex-self-employed. This is key. It's key that they're tailored and defined to your individual businesses. The reason for that is several-fold. First of all, the courts will treat at the outset any restrictive covenants as void unless you can prove that they should be valid. So the burden is on you as the employer. They are void if they go further than is reasonably necessary to protect your legitimate business interests. So if you impose a geographical restriction, that's got to be based on a factual analysis of your customer base. If you extend in time terms, if you go too far in time terms, the clause fails. So you might say, well, you can't compete with me by taking my clients for a period of 2 years. The courts may say, too long, can't do that. It may be that the business purports to protect all of its clients, including those you as the ex-employee have had no contact with and no relationship with. Again, it's likely to fail because it's void. So there are plenty of pitfalls. It is terribly important that you take specific advice on your situation and don't get a generic contract. Plus which, there's another very important consideration as well. Really, these clauses need to be included in the original contract because they require something called consideration. It's got to be value. Normally, if I offer you an employment post, that is the consideration. You agree not to compete unfairly with me.
So it can't be retrospective, basically.
Exactly, unless there is consideration. So partway through the employment, you suddenly think, bugger, sorry, forgive my language.
Oh, say it.
Bugger, I've not got restrictive covenants. I think they're a good idea. Now, ignoring what I said earlier on about hiring, there is some other substantial reason. Let's assume you go to your employee, you say, I need to put some clauses into your contract. They might say, well, I'm not sure about that. And you say, well, in which what I will offer you is, say, £1,000 or £500 or £200, something value for that new promise.
Right.
Then you'll be binding. If you don't do that, then it's likely to be void on legal basis. I mean, this is a really tricky area of law.
It's really, I know, I've been there.
And it can be so fundamental to your business, because if all the clients do walk out the door, what do you do then?
Well, exactly, and that's the key thing. But let's come back to the other area if we can. So we've got so many questions. I think it's impossible to answer all these. But coming back to this fire and rehire again, because this is a position people are in.
Yep.
This is really difficult because, as we said earlier, please jump in. So Karen said, how much time needs to lapse between employed and becoming self-employed? Again.
Well, it depends on whether or not you're actually genuinely changing the status from employed to self-employed. Because if you could leave a gap, if they come back and do precisely what they were doing before, but they're just paying their own tax and national insurance.
That's not genuine self-employment.
What you might find there, though, is that there is a break in continuity of service, so that then the employment law rights clock resets, so that they. Well,
I actually asked that question, and it was in a tribunal ruling, actually, which was really interesting because they actually ruled on it and said they expected to see a break of 12 months.
There is no law that says that there is a.
That's what they said on that judgment. They expected a genuine. Even so, the fact they came back doing the same job, same clients, same days, the same. Do you see what I mean? That's what. So it all falls.
I agree. But that 12-month period, that must have been very fact specific. There is no such law that says that you can have a break sometimes of a week.
Yeah,
and it could be, but it's depends on every single.
Well, it depends on every factor, doesn't it? Because the key thing is, and I think this is where it all. Because coming back to one of the questions earlier, how can I do this? How can I do this and be legally watertight?
Sure. Without wishing to try and tap for legal business, you need to take advice on the precise circumstances of what you're proposing to do at the time.
Your business, your makeup, your staff, how long they've been in service, But obviously, we're looking at an employment law point of view there, and obviously we're going through massive reforms and changes.
Yeah.
But there's another element to this, which is what might satisfy one won't satisfy the other. As in, what might satisfy employment law when HMRC come to check, they'll see it completely differently. And that's the risk that I'm trying to warn businesses about, because that's the risk that can finish a business overnight. And they see it completely differently. And this is why it's really important. And a lot of people say to me, and it sounds awful of me, but I'm doing my own industry a disservice now. People will say to me, well, I asked my accountant. And it's like, well, why did you ask your accountant about employment law? Why wouldn't you go and ask an employment law?
Never do that.
Never do that. Never do that. Because in HMRC's eyes, you cannot split a business to avoid VAT. You know, there's certain things you just cannot do. So, Scott, is a solution to Richard's question. The solution is you seek individual advice, you speak to them on your own business's merit, you make sure that you've got the watertight contracts, because it could depend on what you've already got in place. If you've got a generic contract in place, then you've got nowhere to go. If the intention is to come back doing the same clients, the same day's work, in the same premises, using the same phone number, the same resources, the same juniors, no, it can't be done. So this is where it gets really difficult. Does that make sense to you guys? So let's come back, and then what we're going to do is we're going to do some more sessions on this. Sorry, Marguerite, I know it's a mess. What a bloody mess. I'm going to say it. What a bloody mess. I would be extremely cautious of jumping to self-employment for employed right now. I can imagine HMRC and the government are on the heels of this craze. And overnight, any day real soon, people may be left with an even bigger mess. This is my concern. I'm not trying to, I think there's very genuine self-employed models out there. And the self-employed models I would use would be ones that have multiple engagers, are not treated like employees, don't book through a business, And like your barristers, they shared some admin resources there, Ian, but they're genuinely self-employed and they can prove that.
Yep.
You know what I mean? Same as, a lot of accountants are self-employed, but they work for multiple engagers, they work for multiple people. A lot of lawyers are. But this is different because we're personal service. So we're very personal, hands-on. And it's all about who makes the appointment, who is the consumer booking through. And sadly, we've got far too many cases now in our sector that have failed at employment tribunal and have failed by HMRC. So, Chris, Ian, we're going to finish soon, but I'm going to bring on some more guys. I'm going to bring on some tax consultants on the next one. Okay, so we're going to talk purely tax. Okay, then we're going to try and cross over employment and tax, and that's going to be really interesting. But Chris, what can we do with regards to getting these guys, firstly, the correct contracts and protection? Because I'm really concerned about our salon owners getting caught out here, shall we say?
Just like before, with the work that we've done for your industry, we've listened and we can offer all employment law services, but specifically fixed fees for review of your current contracts. First of all, you need to know what you're dealing with and what you can do, what you can't do, whether you're breaching anything at the moment. So there's a review of the contracts. Secondly, it's drafting, better contracts, because so many people I speak to have just got it off the internet, copy and paste, got it from a generic bank of them, and we know what they're like. And then thirdly, there's a set of up to 27 policies that is available for a fixed fee as well, and they complement the contracts. You might not need all of them, but they're within the fixed fee anyway. So we're there, and Ian can explain a little bit more if needs be, but the full service. So say you're faced with a piece of litigation from a disgruntled employee, we're there for you too.
Knowing what we're dealing with to start with, what you guys are dealing with, that's critical. What have you got in place? If it's nothing, it needs needs to be something. If you've got something that may need changing, but we need to know what we've got, and that applies individually. I'm more than happy to give broad-based guidance, but it's very difficult to rely.
Yeah, it's very difficult, and sorry about, because the difficulty is, we know that obviously, as you well know, guys, being lawyers, there's no kind of yes or no answer unless it's driving at 120 without a seatbelt, and it's clear. But in this case, it can be incredibly difficult, but the onus is on you. As far as HMRC is concerned, the onus is on you to disprove them. And that's the difficulty.
I think we all know that our insurance policy, for example, needs to be watertight, and we all know that our contracts, terms and conditions need to be watertight. So many employers just overlook the fundamental building blocks of their company, which is the employment contracts.
Well, it is.
It'll be all right. It's the elephant in the room, and they've done the sign and forget about them. But
and it's not until you're tested on that, Chris, and this is the key thing. And this is what's concerning. Because obviously we discuss and work directly with government. So without breaching any confidentiality, there's things coming around the corner that really concern me. We've got all the kind of, we've all heard it on the news about tax avoidance being hit really hard in the new year. That concerns me. And we know we've got the Employment Rights Bill reforms, which are reforms. Some organisations are stating that they're actually not in place, but they are. So we've got the reforms like removing worker status potentially. We've got the reforms on, right to switch off, and I don't know how many, if it's 28 or something stupid. But anyway, but that doesn't mean that there's not the tax reforms that are coming around the corner with the new tax roadmap and everything else. Somebody's just mentioned something. I think this is another one, and this is not actually for you guys. Well, it might be actually for you, Chris, a little bit, but this is certainly on government's agenda. What about taking payments on a card machine that splits payments on a commission basis? I think we might be hearing some more in the news about that very soon.
Yeah.
Because I think that potentially could be considered VAT splitting at source. Yes, I know the self-employed, but the point is who's controlling the income, who holds the merchant card account, who holds a contract with the merchant provider. I imagine it's the salon. Does that make sense to you, Chris? This is where it gets really difficult, you know, because if you had to go and defend that, Chris, how would you be able to defend that? And that's the key thing. So I think it's all about, people say hindsight's a wonderful thing. So this is a little bit of hindsight into the complexities of running a business and what we need to do. So anybody out there who needs advice on this, please let us know. I'll put you in touch with these guys, have a chat with them. The first thing is to make sure you've got the correct things in place. And if you've got the correct things in place, protect you and your business, because unfortunately, Ian wouldn't be in a job if people didn't fall out with their employer now and again. Chris wouldn't be in a job if they didn't have, you know, we wouldn't be in a job if everybody could do their own hair. But the point being that it's about protecting your business and your liabilities and not putting your business at risk. So I'm very sorry if we couldn't answer people's question or give you a way to avoid paying VAT or tax or anything, or how to avoid, you know, employment law, because unfortunately we're no longer in the 50s and we all have to adhere to it. Sorry, I don't know if they did have it in the 50s, but I'm sure they didn't. But I'm not saying you two would know because you're far too young, but I certainly don't. But saying that, we are going to go over some challenging times. So please just reach out. Chris and RLK and Ian and team have done an amazing job at fighting for our industry of insurers. Now it's time to underpin your businesses and make sure you're not put at risk. Okay, so I'm going to end it now. Any questions, please come to me directly. I will come on with tax consultants as well, and I might even invite HMRC on. Okay, so you can even talk to them directly and hear it from the horse's mouth. So thank you very much for your time, Chris and Ian. Sorry we went around the houses a little bit, but when questions come up and it's a live thing, it tends to go a bit crazy. Okay, but thank you very much for your time, and I'll see you all soon.
Thank you.
Bye.